morning and welcome to today's Ask a Pro webinar. Today's webinar is what creditors should expect in bankruptcy for 2026. My name is Milos. I'm a shareholder here with Weltman Weinberg & Reese. I've been with the firm for 10 years and I've been practicing law for 22. And in all of those 22 years, I've been working in the bankruptcy field. Gary, you want to introduce yourself as well?
Sure. Good morning, everybody. My name is Garry Masterson. I'm also an attorney here in the bankruptcy group at Weltman. I've been with Weltman for a little bit over 8.5 years, and I am licensed in multiple districts across the country, so get a broad perspective.
Gary, you froze there for a second. That's okay. All right, before we get started, I'd like to take a moment to go over a few housekeeping items. As a reminder, this is, can you hear me, Gary? Hello? Okay, sorry.
You're a little bit choppy. You're a little bit choppy, but.
Okay, all right. We're gonna have to muscle through it because I think we're having some connectivity issues, maybe because of the weather. Before we get started, I'd like to take a moment to go over a few housekeeping items. As a reminder, this is an interactive session, so please submit your questions through the question button in the control panel. Questions will be addressed during the presentation where applicable. This webinar is being recorded. At the conclusion of today's session, a link to the recording and a copy of the presentation slides will be sent to all attendees. Also, there will be a short survey on your screen at the conclusion of the event. Please take the survey and share your feedback. We greatly appreciate hearing your opinions on our webinars. So on that note, Gary, I'm going to pass it off to you to get things started.
Okay, good morning again, everybody. So I know one of the biggest things that everybody on the creditor industry and especially in the bankruptcy world have been wondering for now 5 years plus since COVID hit was, when are we going to see the influx in bankruptcies? And I'm sure many of you, if not all of you, are feeling that we're finally in 2025 starting to come back to a sense of normalcy. Last we were aware, we're not quite at pre-COVID bankruptcy filing levels yet. However, month over month, new bankruptcy filings keep increasing. So before long, we anticipate we will be there, if not surpassing. One of the things that I'm sure many of you have seen is that you may feel busier than you did pre-COVID with less numbers, and that might not make sense to you, but I know a lot of banks, credit unions, and other organizations during COVID had to become more lean or had multiple employees doing multiple tasks, and this may be part of the reason you're feeling busy. Plus, there's been an influx, especially in the last couple of months. So if you're feeling busy, you're not alone. So what we wanted to do to start this webinar is look to 2026. What can we expect? What do we think is going to happen? What do we think the drivers are going to be? And what's that going to do with bankruptcy? So generally, our view for 2026 is we're going to continue to see a continued increase in new bankruptcy filings. It's going to be mostly driven by economic issues, economic pressures, elevated interest rates. While the Fed has dropped rates a few times in the last few months, including yesterday, they still are high. And the meeting yesterday was actually more contentious than normal. And so that would lead me to believe that the chance of future rate decreases in the near future is becoming less and less. Their concern is that if they drop rates too quickly, it's going to cause inflation to tick up more. So that's a delicate balance. So that's going to be one driver. As I'm sure everybody's aware, the cost of everything that you buy hasn't gone down. It's still increasing. And so even if we were stagnant, there's a disposable income issue with a lot of people right now, which is why we're seeing an increase in Chapter 7s. People simply don't have disposable income. And along with that is credit card debt being at a record high. Every year for the last couple, we set a new record. I've seen varying opinions of if that'll continue in 2026. I just saw an article this morning that thought that it would stagnate and we wouldn't set a record next year. I wouldn't take that to the bank. I don't see a reason why we wouldn't continue pushing credit card debt absent some sort of major change. So, you know, if the current trends persist, we're going to see filings continue to increase next year. And one projection I saw was we could reach potentially 600,000 to 650,000 new cases in 2026 if there's not any significant economic relief. And this would be an increase over substantial increase over previous years, but we would still be below the peak seen during major recessions. Think of 2008. But we'll hit on the 2008 possibility a little more in a second. So, as I mentioned, your driving factors here are persistent inflation. You know, if you look at multiple news sources, you're going to get multiple answers of what's actually going on with inflation. The government shutdown took some reports off the board for the last couple months, and so the transparency is hit or miss. But what the fact that it does remain, as I mentioned, we haven't stagnated. Inflation is still increasing, even though the rate has dropped some. High interest rates, as I mentioned, household budgets, just people don't have spare money. And when they don't have spare money, you see the credit card debt increase. People are going to use their credit cards to pay for holiday items, for vacations. And we've seen reports of the fact that people are using pay later for groceries. And to me, that was a major red flag that if people are having to use some sort of pay later just for their groceries, that's pretty telling. As well, you know, those high rates increase your borrowing costs. And so I'm sure many of you have seen what car loans are like post-COVID, where you may legitimately be looking at a loan that's double what it was in 2019 as far as your monthly payment. I don't see that changing anytime soon because beyond the rates, the industry, meaning automakers, I think has figured out that if they keep supply dampened, they can maintain their prices. So that's going to be an issue. Repos are high. I've seen a lot of new bankruptcy cases that those vehicles are purchased fairly recently, if not very recently, and we see debtors surrendering their vehicles very quickly. They just can't afford the payments. Another issue that they can't afford are mortgages, and you're probably not seeing very many. We're not seeing a 2008 at this point as far as mortgages go. Now, whether that's going to happen, it's mixed. A viewpoint that I heard last month at a conference I was at was that they believed, as far as the mortgage industry goes, that 2026 is going to be very similar to the increase we saw in 2025 as far as foreclosure starts. What does it mean for the bankruptcy world? Well, foreclosure starts aren't going to necessarily increase your bankruptcy filings. You need those starts to complete and get to sale. Then you're going to have debtors filing bankruptcy to try to stop your sales. They thought, their opinion was 2027 is when we would see a lot of those starts start moving to completion and sale. So they thought 2027 would be the higher year where we would see mortgages really start to affect bankruptcy. I also saw a report recently that was a little more alarming than that. It was actually a Newsweek report that said they are projecting, their experts are projecting that we may see 2008 issues as far as values on homes. They were anticipating, and I can't remember the time frame, but they were anticipating a 50% drop in house values from where we are right now. If that were to come to fruition, that's significant, because one of the big things that has kept people afloat is borrowing through a HELOC, and they're taking advantage of the inflated values on their home to borrow against and survive. And if the values drop, not only are they most likely going to be underwater on their HELOC, they're potentially underwater on their first and second mortgages. And so that raises their foreclosure risk. One of the items as a driving factor with foreclosures, compared to just not making your payments, was actually mentioned that the two chief factors are the rise in cost of homeowners insurance year over year, as well as the significant increase in property taxes. And so a lot of the experts in the industry are saying that what they're seeing is that you're not seeing your habitual delinquent borrowers for mortgages that are facing foreclosure. They're seeing a lot of first-time delinquents that just can't do it. They can't make the payment because that increase in homeowners and the increase in property taxes is just putting them over the ledge. And so that's significant to think in mind. It may change your portfolio of who you may be facing filing bankruptcy if that continues and that comes to fruition. Of course, if the values were to drop, as they said, that'll have a subsequent effect of dropping the property taxes, but there's a tail to all that. And so my view is, I don't think it's going to be as fast as Newsweek may say. I think what you're going to face is you're going to have to get a lot of more sales through foreclosure, which then are going to lead to a decrease in values, which then will lead to your potential issues with HELOC, but your gain of lesser property taxes. So mortgages, keep in mind, I don't think mortgages are going to be a driving factor in 2026, but yet to be said. As we mentioned, record household debt, depleted savings, that goes along hand in hand with what I mentioned with using their equity. Many consumers have exhausted any of their savings they had from COVID era. And so the buffer they had is mostly gone. I believe savings as a whole are at a significant low amount currently. And one of the biggest factors is the resumption of student loan payments. And we're talking about federal student loans. You may have remembered back in, I believe it was the summer, June, when payments were starting again, there was a lot of news about collection activity on those federal student loans and garnishment. What I had heard was, I believe it was October or November, when a lot of those loans hit the bar where they could start garnishing. So that's something to keep in mind, because even though a debtor might be making your payments, you may be along for the ride. If they can't make their student loan payments, or they're borrowing money from here to make their student loan payments to avoid garnishment, et cetera, they may file bankruptcy, and then you're going to get rolled in. So that may be an increase. Haven't seen the increase on my side yet in student loans and bankruptcy as far as adversary filings, but there have been a few I've had recently, which tells me there's a possibility it's coming. I did hear earlier in the summer from a judge's clerk out in California that what she was seeing was a lot of pro se debtors jamming up their law library at the courthouse, researching what to do about their student loans. And I think we're starting to see that a little bit, not with the student loans, but we're seeing an increase in pro se debtor filings, and those present their own problems as well. So that's something I don't think we're going to see change in 2026. I think pro se filings are going to continue to increase. As I mentioned, the increase has been about across both chapters 7 and 13, but we've seen the largest increase in chapter 7, which matches up with the lack of disposable income.
Gary, that kind of leads into a question we had, and I was kind of waiting for a good time to interject. And the question itself is pretty speculative, but I'll get to the kind of the meat of the question is, how do you see the increased filing shaking out between individuals and companies, 7, 11, subchapter 5, and 13s? You know, hard to say, but, you know, my thought is 7s have always been a substantially large portion. I believe they account for more than half of all bankruptcies filed. I don't think that's going to change. But you did kind of touch on the increase in the 7s, and I don't know if you had any thoughts on that.
I mean, I think the big thing, I've seen a lot of 7s, so I think that's going to continue to drive. Part of the problem I've heard has been those house values are precluding some people from filing because they would otherwise qualify for a 7, and that equity is creating issues. As far as 11s, it's been an ebb and flow. I think we've seen large increases and then we've seen decreases. I think one of the industries to continue to watch with the 11s are trucking industries. At least in California, most of my 11s have been trucking companies that have been filing, and I know I've seen a lot elsewhere too. So 11's not going to lead to charge, but it could be a downstream effect if 7s and 13s keep going up. People spend less money, businesses have issues, and you know they're again along for the ride.
Okay, thanks, Gary. We're going to touch on our next subject, and I do a couple things on the questions. We're getting a lot of questions coming in. We're going to try to keep them on topic, and then if we have questions at the end that are kind of a little bit off topic, we're going to touch on them. But I will say this, I see a question that came in. Thoughts on notice of HELOC payment changes? Had I known what I know now, I think we would have we kind of booked this well in advance of when we thought that the HELOC payment changes was going to be a bigger deal than we initially thought. So I think we're going to save that for a separate webinar altogether. I think it's imminent that we're going to have one there. But what are my thoughts on it? It's going to put a lot of work on the lenders because you're going to have to file a notice of payment change potentially every single month. But we'll shelve that because I think that deserves a webinar in and of itself. I wouldn't do it justice by talking about it for a couple minutes. But jumping into our next subject, I'm going to do something a little unorthodox here. We just happened to get a question from a client that I kind of feel is like captures the essence of what we're going to talk about today. So it kind of reads like a bar exam question. So I'm going to read the question and I'm going to touch on the big issue there, which is credit reporting. That is going to be one of our main focuses today in terms of bankruptcy trends for 2026. So the question, I'm paraphrasing it to conceal names and identities, but I'll give you the gist of it. I have a borrower who filed a Chapter 7 bankruptcy. He was recently discharged and asked if we could continue reporting his loans. He has a first and second mortgage with us, along with a car and a visa. His statement of intention said he would retain and pay, and his attorney generally doesn't have debtors sign reaffirmation agreements. We didn't get a signed reaffirmation agreement back. I was reading the credit reporting guide that says that if the debt isn't included in the bankruptcy, you can report it after discharge. I just know the debtor will usually tell us we weren't supposed to be included, but we are listed. Okay, so there's a lot to break down there. Let's start with the simple stuff here. The first thing that jumps out at me is when someone says, well, the debtor told us we're not going to be included in the bankruptcy, or they didn't list this in the bankruptcy. I get that a lot. I get that question a lot. I get that comment a lot. If somebody files for bankruptcy, you are automatically included. They are not allowed to omit you from the bankruptcy schedules. So when someone says, we're not going to list you, we're not going to include you, that's not true. It's never true. Even if they omit you from the schedules, you're still subject to the bankruptcy stay and the discharge, and that debt is part of the bankruptcy, whether you're on the paperwork or not. Now, whether you get notice or you don't, that's one thing. And that doesn't necessarily change how things are played out. But if you have a borrower who says, we're not going to include you, and they don't list you, or they say, well, I had to list you, but you're not included, that means nothing. Okay, the only true way for you not to be part of that bankruptcy is if that individual signs a reaffirmation agreement, re-obligating himself to that loan. Okay, so on to the second part of that question there. This person did not reaffirm the loan. So what does that mean? They no longer owe the debt. I know it can get a little confusing when the debt is secured by a collateral, such as a mortgage or a car loan. But if somebody does not reaffirm, they do not get, or they're no longer obligated on that debt. So you still have a right to foreclose on the house. You still have a right to repossess and sell the car, but that is it. You cannot call that individual. You cannot send them billing statements. You cannot take auto payments. I mean, that's a gray area if they want. They can make voluntary payments, but if they don't make a payment, you cannot go after them for the money. You cannot sue them. You can't do anything. You're essentially at the mercy of the debtor making voluntary payments on that debt. So now we're going to take that and apply it to credit reporting. This is what we're going to talk about today. In this situation, the individual did not reaffirm the loan. He told the lender that he's not going to include them in bankruptcy, but he did. In turn, he never reaffirmed the loan. So that loan is discharged. That loan is gone. Now he's coming back and he's asking the lender to credit report these accounts. To me, and Gary will agree, that is a hard no for multiple reasons. Number one, excuse me, as a lender, why would you give a borrower all the perks of reaffirming a loan, which would be credit reporting, right? Build up their credit with nothing in return. They can just decide tomorrow they're going to stop paying you, and then there's nothing you can do about it. But you're giving them credit reporting. The flip side of that is if you do reestablish a credit reporting, which you're not supposed to do, and they stop making the payments and they get delinquent, what do you do with credit reporting? Are you going to report them delinquent? That is a clear violation of the bankruptcy discharge. So in this situation, the member at his convenience is asking the lender to bend over backwards, give them all the perks and absorb all the risk. To me, that is a hard no. If you have a member that wants to continue getting his debt reported to the credit reporting agencies, they have to reaffirm the loan. There is no way around it. There's no circumventing it. There's no backdooring it. Nothing. Okay. So now we go to, before I jump that, Gary, do you have anything you want to add to that question?
I completely agree with Milos. One thing I would add is it's always a common thing. I wouldn't say common, but some debtors' attorneys will ask, well, why should my client reaffirm the loan? What's the benefit? And my answer usually is, well, if they're going to pay, it's credit reporting. And so it goes right along with that. But definitely, you can't and should not be reporting in that situation.
Yeah. And the one thing before we get into the credit reporting, I'm not telling you how to report. You guys have your guidelines on how you do that. And there's, you want to continue following those guidelines, but we are here to tell you, if you report things a certain way, how can that create a problem with the bankruptcy? Well, let's start with the situation in this case. All right. The individual debtor here did not reaffirm the loan. So if that's the case and the case gets discharged, you are not credit reporting. Okay. The door swings both ways. The member should not be getting the benefit of that account being showing up in his credit report as being paid in current, if they're paying in current, because they absorbed no risk. On the other side of things, if somebody files a bankruptcy and they get the discharge, the whole reason they file the bankruptcy is to wipe out the debt that they owe and get a fresh start. If you don't follow your credit reporting guidelines and still show a discharged debt as an active account, and you're showing delinquencies and missed payments and charge-offs and everything that would hurt their credit going forward, then they receive no benefit of that discharge. And I think if somebody were to press that issue, that's a potential violation of the discharge injunction. You know, what's the point of somebody discharging a debt if they're still going to get penalized for it? That was supposed to be wiped out in the bankruptcy. So it swings both ways. They shouldn't get the perk if they don't reaffirm, but then if they don't reaffirm, they should, you know, they should get the benefit of the discharge and not get penalized financially. Because I think the worst thing you do to somebody is hurt them financially after they get a bankruptcy discharge. And I think the first thing that rushes to people's minds is, well, the bankruptcy got discharged, we can't sue them, right? But I think credit reporting now, or I mean, always has been, your credit score means a lot. If your credit score is continuously in the, you know, going down or going the negative, and you receive no perk from that bankruptcy filing, then I think that's a problem there. And the reason this has come up and now, you know, as we say, it's a hot button topic in 2026. I feel like it was a hot button topic in 2025. People are much more savvy now with credit scores. I mean, you know, as we're going through this webinar, I'm going back and thinking, you know, when I was younger, I remember as a kid going with my dad to purchase a car, and the guy would come in from the dealership and say, oh, you know, you got a good credit score. Yeah, how do you know that? There was no place where we didn't have the internet, right? You'd have to, would you mail it in? Where do you know, these companies have, I guess, software or programs where they have access to that, but your average person on the street couldn't just get their credit report. I mean, a lot has changed since then. The government gives you credit reports, not necessarily your score, but you kind of look at, you know, what's on there. And with the internet now, and, you know, Chat GPT and all that stuff, people are much more savvy with their credit and their credit scoring. So that's why this has come to the forefront. Is I think a lot of times, you know, historically, I remember somebody wouldn't come up and say, hey, you're misreporting my credit arbitrarily. They'd maybe go try to get a car loan or try to get a home loan, and then something comes up, and then they'd have to go and remedy it. Now I think people look at their credit as soon as the bankruptcy is completed to make sure everything's been discharged and wiped out, and you know, they're kind of going through that with a fine-tooth comb. And I think as a lender, I think you have to make sure that credit reporting complies with your rules and complies with the bankruptcy code, and everything is nice and tidy when somebody completes their bankruptcy. So that's like the biggest, you know, thing. You know, be aware of that on the back end. When the bankruptcy is filed, you know, that automatic stay goes in. It's like, yeah, we got to notify our repo company not to go after the car. We got to notify our attorneys not to sue him anymore. We got to stop the auto payments. We got to stop the foreclosure. You got a credit report too. You got to go in there, see what your guidelines, touch base with your compliance department or whoever you guys consult with for compliance, and make sure you are reporting everything accurately when somebody files for bankruptcy, and especially if somebody completes a bankruptcy. So anybody, you know, I'm encouraging any questions. If anybody has any questions or concerns or some real life examples they want to share, feel free. Gary, did you have anything you wanted to kind of add to the credit reporting or anything that you've seen?
I think one of the things that sometimes becomes a little bit confusing for creditors is, especially in a Chapter 13. So you have a borrower, one of the borrowers files for bankruptcy, and you now have a non-filing co-borrower on that vehicle loan, for example. How do you report? What do you do with credit reporting? And, you know, I'll say a couple things. I've not seen a lot of litigation on it, but I feel like that is because the bankruptcy attorney in that case is not representing the non-filer. But you do need to be careful, because there is the co-debtor stay that's in place, and it can create some awkward issues for you, both for, you know, communication and payments, but as well as credit reporting. And there's a lot of times that non-filer might not even be aware that the primary filed bankruptcy. And they're not understanding why, they're not getting statements, or, maybe there's a credit reporting issue, and there's only so much you can tell them. And then there's a lot of, I've seen both ways that some attorneys, be upset if a creditor is not credit reporting on the non-filer, but conversely, I've seen attorneys be upset that creditor is. So, my precaution is remember that stays in place and proceed that way, because the worst thing you want to do is report delinquent in error there too, because maybe that's not being paid outside the plan. You're being paid by the trustee, and as we know, you're not going to receive either your normal contractual payment amount, or there's going to always be a timing issue for the disbursements, and you're potentially going to penalize that non-filer when they're currently protected. So keep that in mind. It becomes a little more murky when it becomes a direct pay, but like I said, I still would proceed cautiously in the absence of somebody giving some sort of permission in writing. You're still going to have a stay violation issue. But I think that's the big one I see, as well as, like I said, you just deal with the non-filers that just don't understand what's going on and why they're getting looped into a case that they're not involved in.
Yeah, it is very tricky, because we have a very good question here that kind of segues from how you finished that last statement. Is how about a Chapter 13 repayment outside the plan with credit reporting? Does it start after the bankruptcy discharges? I do feel, this is my thought, I do feel that the credit reporting issue is going to resolve itself here in the next year or two with the courts, because I think when this bankruptcy code was contemplated, especially back in originally drafted, I don't even know the exact date, but it's been 50 plus years ago. I don't think that credit reporting was really like a thing. So how, and we're probably giving you more questions than answers, but I think your first step in those situations is, what does the plan say, right? And if it says the debtor or the co-debtor are just going to continue paying the payments directly, contractually, how do you report that? I don't know. I feel like you either put it as pending bankruptcy. I think that's an option that I've seen, right? And then when the bankruptcy is done, you figure out where it's at, and then you resume your normal collection. Or if the plan provides for direct pay, you just report it as normal, because the plan kind of indicates that nothing should change, right? Especially if it's a long-term debt that extends beyond the end of the plan, it's not going to be subject to the discharge. I can't give you a definitive answer on a lot of these. I think it's going to be wait and see, but I think what the plan dictates is probably going to be a good indicator of how you're going to approach it, how you're going to handle it. I do think Gary's example is the most difficult, because there is a co-debtor stay in a Chapter 13 on consumer debt. And if the individual co-borrower files bankruptcy, let's say here's a common example, they're a divorced couple, they had a joint credit card together. Pursuant to the divorce decree, the wife agreed to just continue paying it, and they're not going to refinance, she's just going to pay it and keep the spouse out of it, right? As long as they're paying, they're not going to violate the divorce decree. Now, one spouse files for bankruptcy and includes the credit card because they're required to, it was never refinanced, and the other spouse is trying to pay on it. Well, how do you balance her obligation on the divorce decree versus the co-debtor stay? If you comply with the co-debtor stay, you shouldn't be collecting on her, you shouldn't, everything kind of freezes. But then it's a difficult situation. I don't think there's a perfect answer, and I think it's one of those things and I think an astute debtor's attorney would probably want to look at that and get that sorted out with his client, and even on unsecured debt, Like you see that where a debtor's attorney will file and say, you know, this is a joint credit card with a non-filing spouse or a child. They're going to continue paying it outside of the bankruptcy. That's great. I think that's the solution. But if an attorney is not on top of that, doesn't do that, that puts you in a difficult position. I think ultimately, I don't know. I think the automatic stay in federal law, I think it supersedes any other rule. So I think until you kind of figure out what's going on or get things sorted with the parties, I think you have to terminate all collection action and put a hold on the credit reporting, at least until the bankruptcy is resolved or until you determine who's doing what. It's a difficult situation. Here's another situation. What if they only reaffirmed on part of the debt but not the full debt, like a cram down? What does credit reporting look like in those cases? I'm not quite understanding the question, but I'm assuming it's one of those situations where this is an assumption. If you want to send a follow-up to kind of clarify, but it's rare but not uncommon where somebody files a bankruptcy and they reaffirm and they negotiate the terms of the loan to either reduce the principal or reduce interest or reduce, change the loan terms or change the monthly payment. If somebody reaffirms a loan and the terms have changed, either reducing it or cramming it down or whatever, that's a voluntary decision. If you decide to do that with a customer, that's completely up to you. But if you do that, now you're bound by it. And I think, my position is, and Gary can give his input, but I think I kind of see eye to eye on a lot of this. If you agree to drop your principal to $10,000 and reduce your interest to 5% and change payments to like $150 a month, then the loan is permanently modified. You got to look at that reaffirmation agreement. That's what's controlling. If you change the terms of a loan through a reaffirmation agreement, I think that is the same as modifying a loan. And I think you have an obligation to report that reaffirmed debt to the credit agencies pursuant to the modified terms.
I completely agree. The easiest way to think of that reaffirmation agreement is that's a modification, it's a new contract, and whatever is in that contract is what you're reporting on. If there's a $25,000 car loan and you reaffirm $15,000, my view is the other $10,000 is discharged. And so all you're entitled to report is that $15,000, the payment status on it, and do they make whatever that monthly payment is.
Yeah. And on the flip side of that, Gary, my thought is, if you do modify it, you got a credit, and they reaffirm, you got a credit report. I think that's one of the biggest selling points for somebody to reaffirm a debt is like it rebuilds their credit. If you agree to take a reduced interest and you agree to take a reduced principal, but then you don't update your system, you don't report it accurately because it's too hard or our system isn't capable of doing it, you probably shouldn't have agreed to it, because I think you're really exposing yourself on the back end if you agree to change the terms of a loan and then you don't adhere to the terms of that agreement. Oops, I'm sorry about that. So I think beware when you're reaffirming a loan, especially if you're changing the terms. Just signing the paperwork isn't the end of it. It's getting everything kind of set up in a way that it complies with the reaffirmation agreement. Even if the terms aren't modified, one of the common questions I get is like, well, they reaffirm, where do we go now? What do we do now? The easiest way for me to explain that, if somebody signs a reaffirmation agreement, they're re-obligating themselves on their debt, and that's when that debt is like not included and survives the bankruptcy. So as soon as that paperwork is signed and filed with the court, my thought is you just resume everything back to normal. Credit reporting, sending billing statements, everything is back to pre-bankruptcy status when somebody reaffirms a debt. I think a lot of our clients overthink it a bit and be like, well, they signed the reaffirmation, what are our rights? All your same rights that you had before. Gary, if there's anything you want to add to that, I don't see any new questions. I think we may jump to our final topic and then leave some time at the end for questions.
Yeah, I think before I jump to the final topic, I would probably leave this session with one interesting question I would pose that I've had come up a couple of times, which is um, situation where you're in a Chapter 13 and you're being paid through the plan as a secured debt, and your loan gets paid off into bankruptcy. Your account's paid in full. How do you report that? Because I've seen both ways. I've seen it reported as discharged, and I've seen it reported as paid. And I've had situations where the lender reports it as discharged, and a lot of times with credit unions, the member will file a complaint or will dispute and say it should show as paid. Um, I'm honestly 50-50 on that. I think the safer path is discharge because it 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 it, it was discharged. I could see paid, and I think where I've landed with creditors has been, to report it initially as discharge. If somebody causes an issue, then you can always reevaluate on a case by case. But I don't think you're doing anything wrong by reporting that account as discharged in bankruptcy. Milos, do you have a thought?
I mean, if it's discharged, it's discharged. I don't think there's any way around it. How would anybody argue otherwise? I think if you do anything other than that, if on an unreaffirmed debt, then I think you're putting yourself at some risk. Even if it's minor, I think you play it by the book. So, all right. I think we don't have any other questions specifically with credit reporting. Let me just. That's a good question, but it's a little bit off topic. So I want to give Gary some time to touch on lien perfection, which is our other hot topic for 2026. And then if we have some time at the end, I'm going to circle back on some of these questions. So Gary, if you want to take it away with that.
Sure. So I know any of you who have attended multiple of these bankruptcy webinars we've presented, you've probably heard this topic be brought up before, but lien perfection. It's just extremely important, and we continue to see it as an issue, and it's a significant issue that really can cause you losses. So it's important to stress and cover. So if you take nothing else from this portion of the webinar, just remember this one takeaway. As the lender, it is your responsibility and only your responsibility to make sure your lien is perfected timely. It's not the member's responsibility. It's not anybody else's. It's yours. And this is something that we run into many times as a reason why a lien wasn't perfected. Generally, there's some state laws that maybe give you a little more, a little less, but from a bankruptcy perspective, you need to make sure to perfect your lien within 30 days of the loan. If you don't, you're exposing yourself to being treated as an unsecured creditor in the bankruptcy. Now, before I get into the ramifications of not timely perfecting, what happens if I have a loan that's taken out and the debtor files bankruptcy within 30 days? So I still have some of that time. I've had a few of those situations, and that's where I feel, at least with my trustees I've dealt with, I can make a pretty good argument that you did not have your time exhausted. At the point when that debtor filed bankruptcy, you couldn't perfect because the stay is now in place. And if you were to perfect that lien, so if they filed bankruptcy on December 10th, and maybe that was 20 days into your 30-day period, here on December 11th, if you perfect that lien, that's a stay violation. And most likely the trustee is going to probably seek to avoid your lien. What I have done before, and it's been successful, is you can try to get limited stay relief just for the sole purpose of perfecting your lien. But if you do that, just keep in mind that that order is very narrow. When I've done that, the orders have stated specifically it's solely for that purpose. Otherwise, the stay remains in effect. And in this example, if you're already at day 20, once that relief order is effective so you can perfect your lien, that clock is ticking again. And so you better move to get perfected within, in that case, those 10 days. Now, a situation sometimes comes up is I've mailed all the paperwork to the DMV, but after I mailed the paperwork and before the lien has been perfected, actually noted physically on the title by the DMV, my debtor files bankruptcy. In that situation, that's not a stay violation, because when you mailed all the required documentation to the DMV, it was out of your hands at that point. Now, if you would sometimes have a trustee that would come and say, oh, I see that, you know, the lien was perfected 35 days after the loan. One of the common questions I'm going to ask my clients is, I see we didn't perfect timely. I need all the information you have. I need to know what steps did you take? When did you take them? What issues did you run into? And most importantly, if you mailed the application to DMV and that was within 30 days of that loan, I want a copy of that application and any sort of proof you have that when it was sent to DMV, because I've had situations where that gets a creditor out of jail, so to speak. I take that and I send it to the trustee and they back off. Because if push comes to shove, like I said, that was out of your hands. You timely took the steps to perfect. It wasn't your fault that the DMV drug their feet. Now, just to be clear, you may spend some money on that still to make sure you keep your lien, because you might come across a trustee or a debtor's attorney, most likely a trustee, who is insistent that they're right. This situation you'll see a lot will be where, again, I know California and Arkansas, a lot of times the date that you see on the title for the lien is actually the date that the paper title was issued. So that can be misleading. And so my recommendation there is, just because a trustee comes to you and says, hey, creditor, you perfected 36 days after the loan, send me the title, you're going to be unsecured. Get with us, get with your attorney, because you may have a defense. I've had those situations, specifically both in those states, that we've succeeded against trustees, because I've told them that date you see on the title is not actually the lien date. If I go to California and I request as a creditor a paper copy of that title, every time I do that, that title issue date is going to be the date that the DMV prints that title and mails me the copy. That doesn't mean that's my lien date. And so in that situation, you may have to do some legwork. You may have to go to DMV and say, I need copies. I need copies of when you process the lien. Can you give me any sort of records you have? They have those records. It may take a long time. So that's why I really recommend keep good records, because it is much easier, much quicker, and much less costly for you if you run into this situation to be able to pull out a application that's signed and proof of mailing to DMV and put it down on the table and say, here, This is why it's timely perfected. So those are sort of the things you can do to try to help you out if that situation arises. Now, what is not a good defense? So saying, well, we entered into this loan with this consumer, and we told them they had to perfect our lien on their title. That's not going to fly. It's not going to work. It's not their obligation. You may have a contractual term that says they have to do that. As far as bankruptcy trustee is concerned, they're going to be able to avoid your lien and treat you as an unsecured creditor in the case. And your only hope at that point is most likely cross your fingers and hope that case dismisses at some point. Otherwise, you're going to be at the mercy of what unsecured creditors are being paid. You basically lent that car with an unsecured loan. Now, if there's a situation where you need something from the debtor, so I see a lot of these situations where a state requires you need something signed by the debtor, whether it's an application, whether it's power of attorney, things like that. Okay, I understand that. Make sure you stay on top of that. I've seen a lot of times where some creditors will, send the paperwork out, make one call to the debtor, and then, well, I did what I need to do. If they get it back, they get it back, and they don't track that. You need to track that closely because remember, you got that 30 days, and if you don't do it, they're going to be looking at you. Also, you may run into the situation, which we see a lot, which is refinances. So you will have a situation where, creditor ABC had the lien on the vehicle. The debtor comes to you, they refinance their vehicle. And so, that old creditor, they don't have skin in the game, really. They've gotten paid off, you've paid off their loan. They might drag their feet in releasing their lien so you can get your lien on the title. What do you do in that situation? If there's a reason you can't get your lien on that title with DMV, whether it's that situation, whether it's the state is absolutely requiring you get some sort of paper from the debtor and the debtor's just stonewalling you or ignoring you, my view is record a UCC. Get some sort of lien on that vehicle, because not only are you facing the possible bankruptcy issue, but if somebody records a judgment lien in that county, it could apply to personal property, and so now you're not protecting your first lien holder right. So generally, if you don't, as I mentioned, if you don't have a timely lien perfection, any good trustee is going to figure it out, and they are going to treat you as unsecured. I've had situations where they handle it different ways. They file adversaries. Had one that I settled that they were in agreement that the creditor would be treated as unsecured, and the creditor, I believe, had to agree to send the trustee the title to hold with their lien signed off on, not sent to DMV, but they're them signing off and releasing the lien, sending it to the trustee. Trustee holds it for the duration of the case. If the case completes, your lien is gone. They're going to give the clear title to the debtor. If the case dismisses, the agreement in that case was they send the title back to the creditor. Had another situation where they went to sell the vehicle. That's a possible situation too. So really the ultimate lesson here is it is absolutely important that you timely perfect that lien. And if this means you have to audit your processes, I strongly recommend you do. The trustees and the courts are not going to care if you're a small institution, if you're a large institution. You have to timely perfect that lien. And what they don't want to see is they don't want to see excuses. And they definitely don't want to see trying to pass blame. Final situation is you have that refinance, and maybe you have a third party that manages that process for you. So you don't handle the lien perfection in-house. We've seen problems with that too. It's fine to use a vendor or a third party. Just make sure that your compliance department or your legal department has some sort of protection in place, whether it's a buyback clause or some sort of remedy. We've had situations in the past that we've gotten our clients out of situations like this because we noticed in the documents that ABC company was responsible to make sure that that lien got timely perfected, and they didn't. And so we get notes and realize, wait, they didn't do their job. And so my question to a client normally is, okay, here's the easiest resolution. We don't have to fight with the trustee. Do you have any agreement with this third party that if they don't get your lien timely perfected, you can force them to buy back your loan? And what that means in the bankruptcy world is they're going to literally need to buy back the loan, and it's their problem to deal with. They caused the problem, it's their problem to deal with going forward. So if you have that, keep that in mind. That's a tool in your tool belt. If you don't have that and you use a vendor, I would strongly recommend considering that as a option in the future. And I will turn it over to Milos for any questions we have while we wrap up.
Thanks, Gary. Just to kind of follow up with Gary, I agree. The moral of the story is no one's bending over backwards to put a lien on the title for you. It's benefiting you and you only. So I think the responsibility ultimately falls on you, and you need to stay on top of that. And a situation I had, one example that I had is, we had a client who didn't get a lien perfection, and the member filed bankruptcy, and they said, well, he never made an effort, and we think there's fraud there. And I look at the situation, I'm like, well, he bought the car a year ago. You sent a couple letters. You didn't, use any of your state, court remedies. You didn't take any aggressive position to enforce it. What's his motivation? So I think staying on top of it, being very aggressive, perfecting lien on title protects you, and is a huge protection, especially if it's a larger balance loan. You have to put in the work. And I think on the back end here, I always encourage our clients. I know it's easier said than done. We get manpower, time. You definitely want to audit those files to make sure you have a lien on the title. So going to questions, I was kind of looking through them as Gary was talking, and we got like 2 minutes. Nothing was really specifically on point with our topic, so I'm going to grab a couple of random ones that are here. I think we have time for maybe one question. This one's actually pretty good. We'll kind of close on this. We have a member that has a discharge first and second for about $255,000. The foreclosure was reinstated. She released a call requesting a forbearance. When we told her she was not eligible, she said she just filed a 13. She doesn't owe the debt. How could she put this into a plan? I think that's a great question. I think it applies to a lot of people. Not uncommon. I think in our industry, they call it filing a Chapter 20, where you follow a 13 immediately after following a Chapter 7. Are you forced to comply? I think so. The house is in the name of the debtor. It is an asset of the estate. Although their personal obligation is discharged, there's still an obligation on the home. So I think, in those situations, I think it's generally considered that they can do that. I think where there's a slight distinction is if they're not the actual owner of the home. So where would that happen? They inherit a house from a family member that's passed away, and neither the loan nor the house are in the name, or maybe the house is in the name but the loan isn't. I think you have a little more leverage there to say, we don't want to participate in the plan because the person doesn't own the house, not their house, or it's not their loan. I think where it's been discharged, it's a little different. Unfortunately, I think that's pretty generally accepted. I think, Gary, would you agree?
I completely agree. It's an asset of the estate. If it's in that debtor's name, you're bound to comply. If you need to object to some sort of term in that plan, of course, but you can't just look the other way.
Yeah. All right. On that note, we are at the end of time. I have some closing remarks, but before I get into our closing remarks, we had some good questions there. If you have any questions, whether they're on topic or off topic, please feel free to reach out to me or Gary. You can shoot us an email with your questions or give us a call. We'll try to address them as timely as possible. So on that note, thank you for attending today's Weltman webinar. We hope you found this presentation informative. As a reminder, a short survey will pop up on your screen when the webinar ends. Please share your feedback and let us know what future webinar topics you would like to see. I would also like to share that we have a complimentary library of over 40 webinars that you and your team can view on demand. Our collection offers information on various topics such as collateral recovery, real estate, and bankruptcy, to name a few. We'll send you a link to the library in our follow-up email. Thank you again for attending, and have a great rest of your day. Thank you guys very much.
Thank you.